harassing us. The land belongs to the builders. Stop harassing us. The land belongs to the builders.
These are protesters demonstrating in solidarity with the Meadows family's claim over the disputed Monkey Village. The property, located at number 1 Folorunsho Kuku Street in Opebi area of Lagos, an area popularly referred to as Monkey Village, has been a subject of litigation between a former vice president of the Nigerian Bar Association, Barrister Monday Ubani, and a Lagos socialite and real estate mogul, Engineer Abiodun Ariori. While Barrister Ubani insists a portion of the land rightfully belongs to his client and labels the Engineer Ariori as a land grabber who has been using the state agencies and land grabbers as tools to steal people's property, Ariori Golden Ventures Limited, on the other hand, holds firmly to their client's legal evidences and Supreme Court decisions, and with the help of the Lagos State government, enforced an eviction of all occupants in the property, including a massive demolition of illegal structures and shanties. Surprisingly, scattered in the midst of the ruins and debris are a countable number of people clustered around, homeless and confused. Their homes were part of the illegal structures demolished by the Lagos State government during the eviction exercise which took place in December. Defending their actions, lawyers to Engineer Abiodun Ariori and the Meadows family spoke to journalists on the site, insisting the takeover possession was done within the ambit of the law.
But because of maybe the fact that the family is not financially solid, that is the reason why they've not been able to physically develop most structures like residential buildings. But the truth of the matter is that the antecedent of ownership made them to even sue property owners within this street very many years ago, okay? Like people who trespassed on their land, people who came on the land, built structures and were living there, okay? Like the dominant ones were like people like the Kuku family. They came on the land, and naturally what happened was that they took them to court, claiming ownership, that this portion of land where you are belongs to the Meadows. So that matter went to the High Court. At the end of the day, there was a kind of compromise because that family, I think a composite survey was drawn. The court ordered that survey be drawn. So, and that survey now would explain the size of the land, the futures of the land, and the position of the parties, particularly the parties that were in litigation at that time. So the position of the parties and the size of the land became an issue for adjudication by the court. And the aftermath of that was that there's a judgment. The suit, part of the suit that we know, was a suit in 1980, and that the judgment, the decision of the court was by Justice Famake. While there are other judges that had, their own, what would I say, that they give their own, they also adjudicated on the matter at various stages of the proceedings. The matter can be before one court for an issue, another judgment. But the important thing is that the decision in all finality was tried by that court. At the end of the day, those that were dissatisfied decided to go on appeal, and also the Meadow family pursued the appeal diligently, and they got judgment even pronounced in their favor by Justice of the Court of Appeal. When the matter also went to the Supreme Court, it was also in their favor. As at 1988, judgment about this court, about this land was delivered. And from there, then, everybody around had notice of the judgment. The issue of notice, the people here, I think they were notified adequately that they should leave. The owner wants to develop his property. They don't have any, there's only a person that has the dominant title against my title that can be contending the issue of it, but they were adequately informed. But most of them became recalcitrant. The natural trait is that they are not responsible to anybody. They came in as porters. Look at the legal shanty towns within a city like this. And the complaints our clients were receiving about what is going on is that this place now became a haven. Okay, like I said, for all sorts of crimes. Okay, people that are illegal immigrants from nowhere they come. It's more like a training front for robbers, a place where they stash proceeds of crime. They come here to conceal either stolen vehicles or stolen materials And this place also became, you know, a kind of terror to the environment. There are issues and incidences of people around. You know, most of the people around here, they are people without any reasonable means of livelihood.
He's claiming that he has some portion of his property within our property. Unfortunately, from all indications, since we have been interacting and interfacing with Barrister Ubani, it seems there is more to it than meets the eye. Firstly, at the first time we had interaction with Barrister Ubani over the same portion of land, he claimed that one Yoruba man, I cannot pick his name now, is the owner of the land, an individual. At the second time we had the opportunity to meet again at the Zone 2 Police Command, Barrister Ubani claims that the property belonged to one barrister, Usa Udausa. By privilege, I've had the opportunity to see what is said to have been filed by Barrister Ubani in court. And in that process, he's claiming that one Circus Nigeria Limited is the owner of the property he is addressing. 2, the purported CFO, Barrister Ubani is flying around, does not have any of these names. He has not been able to connect what we call nexus in law, the position of his clients with the land so far. We have had the opportunity of interacting, and we see that at every material point in time, when he had the opportunity to show forth his claims, he had always hidden under one excuse or the other. Even as late as last week, when we were invited by a panel at Alausa, he was called by Barrister Ubani, who had been cited in Lagos, claimed to have gone to his own village and not to be in Lagos. So from all the plethora of facts that we have before us, it is very clear that Barrister Ubani is up to no good. His claims are not founded in law. We have judgments of courts here. Here with me, I have the High Court judgment, the Court of Appeal judgment, and the Supreme Court judgment, all affirming us as the owners of this land. We don't know where Barrister Ubani got his land from. He claimed.
While speaking to journalists after the panel, Barrister Monday Ubani explained what the whole saga was all about.
What happened was 6 months ago, some people invaded the land with mopo and thugs, and they arrested the mechanics that were on site, and with a sundry allegation, and went and released those mechanics, and then came to the people that were there. Say, who put it there? They say one man. Eventually, the man owned up and said that he has a Supreme Court judgment, and that he has already executed in 1989, but that our clients retook possession, and that's why he has come now to enforce judgment. I say, well, if you enforce judgment before, and somebody now repossess it, the proper procedure is for you to go back to the same court in order to do restitution. But let us see the court judgment. So I was able to look at the court judgment. It's a Supreme Court judgment with regards to Abuloni Bagbo. And even the warrant of possession was saying, number 1, Ibadan close on the Bagbo. And so I now say that these things are contradictory. That if you are talking about a property that is in Onibagbo, and here is Opebi, there are two different things. But they say that the survey, indicated that that land is included. And I said, what survey? They brought a survey that is drawn by one Ogumbi surveyor, Ogumbi in 1981. I said, well, this particular survey was not part of the proceedings in court. And I didn't know that they went and convinced the land grabbers unit to come, and they did their investigation, and they did the investigation based upon that survey they submitted, and not the survey that was tendered in court. And I said, and they now gave evidence that the land fell in, and so they now went to come and enforce. And before you know it, they destroyed all the fence, the side fence, and then destroyed everything, and then gave possession now to the land grabbers, who are now planning to build. And I wrote petition to the Lagos State Governor, who constituted an inter-ministerial committee, and they explained their part, that what they did was based upon document they collected from court, and that survey of 1981 was from the court. I said, which court? The court couldn't have given that survey as part of the proceeding in Miado's case that they had, that led to this particular Supreme Court judgment, that land, that particular survey was never used in that court. But it is based upon that the surveyor gave the evidence, gave the report that our land fell into the land of Miados. So I have given them the survey that was tendered, and they are looking at it now. So Lagos State is trying to exonerate themselves and say they acted based upon what was given to them from the court, and they felt that there was a particular judgment and that they had a right, to be in that property. So that's okay. Well, you have explained yourself, but I'm saying that survey, I have no confidence in that survey. It was never used in the proceedings, and you cannot just bring it in now and say it formed part of the proceeding that gave judgment that led to that judgment that was affirmed by the Supreme Court. So that is actually where we are now. So they will do that, but the matter is in court. And I also reminded that this matter is in court. They cannot be resolved by the panel. It's administrative. They cannot be unbiased. They cannot in any way be do the job of a court. And but they are saying, oh, Miado was not sued. I say, well, if Miado is not sued, you are the one that hired the person that I sued. I don't know whom the Miados are. Nobody has come out and said I'm Miado or I'm representing Miado. This is the man that representing Miado. So it is either his assigns or his listen. And the man that I know is the man that invaded the land. That is the person I sued. He should come to court and give explanation as to how they invaded the land and how they obtained the court judgment.
But you said there was a court injunction on that land.
Yes, I even got court injunction against them. This Ariori, Engineer Ariori, was served personally. Come, gentlemen. Come. These are my lawyers. Come. Okay. My lawyers were the one that even served, was there when they served Ariori. Engineer Ariori denied that he was never served.
Okay.
Even there was
please, they can come on camera, please.
They were served. Were they not served? They were served personally. They met him where he was drinking one night and served him. Even after substitute service, they pasted in his last known address.
That's who exactly was served?
Ariori.
Abiodun Ariori.
Ariori, yes, he was served personally. After they have even pasted, we have all the proof of service in the court file.
I would say that what he has been doing is approbating and reprobating. Before the panel here today, he said he was served in a beer parlor. I wonder how a lawyer will say they served the court process on somebody at a beer parlor. That's one. He has said in other quarters that he could not serve him and that they served him by substituted means. You see, one thing about service is if you want to go by personal service, you serve personally, and then you depose an affidavit of that you have served personally through a court building. Now, if you want to go by substituted service, that means that you would have made an effort at personal service. So if somebody is coming to tell them in the Ministry of Justice that the person was served at the beer parlor, it leaves much to be desired, then why did he have recourse to substituted service? Now, the truth of the matter is that we had maintained strenuously that Engineer Abiodun Ariori was not served, though they have been saying that he's named at a party in the proceedings. We heard it over the media, print media, everywhere. Okay? But the crucial thing was that when we got information here that they said there's a court process being served, there's an injunction, I took the pains because I told them here that if there's any court process touching on our clients, we are ready to challenge and get it set aside because we know we are not afraid of court processes. What we did was that we approached the courts with our proper application to conduct the search. We found that, number one, Abiodun Ariori was not served. He was not served. In the court's file, what you find is a proof of service saying they served the defendant. In that suit we are talking about, there are more than one defendant. So if you have to, one thing about law is that you have to be specific and you don't have to plead what is vague or ambiguous because the law does not speculate. So now, the fact is that they said they served the defendant. Which defendant? Then the pictures that were exhibited, when I had the cause to show my client the picture of the house, it was laughable. It is not his house. The house does not belong to him. They said they served at 9 Abiodun Ariori Close. He lives at number 9, Sewage Road, Ruwan Estate, Beda, Lagos. They said they made attempts on the 22nd of June and on the 16th of June, and that the security man said he's not going to collect the process. That means that they would have met somebody.
Samuel Adelaja, reporting for Star Media Renaissance TV.